Hi, this is Denny Lee of Lee Law Office with another episode of Answering Your Estate Planning Questions. So what's the difference between having a trust and naming successor trustees and having a durable financial or property power of attorney? Well, the difference is subtle, but it's important to understand the differences. Powers of attorney exist until we die. At the moment of our death, the ability of the agents that we name in your power of attorney, that authority ceases to exist. So powers of attorney are fully operational during the time of our lives. Upon death, they don't function anymore. That's a big difference from naming a successor trustee in a trust, because the successor trustee has your authority through your appointment of a successor trustee or co-trustees to handle and act on your assets during your life in the event you become either temporarily or permanently disabled, and that authority, by virtue of the terms of the trust and Nebraska law, continues to exist after you're dead. And so from that standpoint, while the power of attorney ends at the moment of death, the authority of the folks that you name as successor trustee or successor trustees continues to exist after your death. And for that reason, that's one of the critical advantage and components of doing a trust instead of just relying principally on a power of attorney. I hope you found this helpful. If you have any other questions, let us know. I'm happy to answer those. If you have anything you want more information on, just go to our website, leelawoffice.com. There's a lot of helpful resources there. You also have the opportunity there to watch our on-demand estate planning webinar. It takes about an hour and 15 minutes. I talk about wills, probate, dying without a plan, how a revocable trust eliminates the need for probate when it's properly done and funded, powers of attorney, both property and healthcare powers of attorney. And we also talk about, which is important for many people that do not have long-term care insurance, and most of our clients over the years do not have long-term care insurance, what steps are potentially available to protect our valuable assets, our home, investment accounts, other high dollar value type of financial accounts from having to be subject to a Medicaid spend down in the event a health event befalls us and we start having to use our own money to pay for our own nursing home care. The average nursing home expense in Nebraska right now is at $100,000 a year. We know it's not going down, it's going to go up. So we've been very busy helping people identify the planning strategies to protect those assets with what's called an irrevocable asset protection trust. All that information that I've just shared with you is on our website. So if you have any questions, check that out. You can give us a call at 402-934-4409. You can also email us at legacy@leelawoffice.com. Thanks for watching. I'll have some more answers to your questions next time. Take care.